Okay. So let's get started here. And some of these things I'm going to skip through, again, because Stacey's going to be talking about them. So Social Security has a definition of disability just like any other benefits paying organization does. The VA has a definition of disability, vocational rehab has a definition, and we have a definition. And it is, let me just unpack it a little bit, the inability to engage in substantial gainful activity, also known as work. So you can't work because of a medically determinable impairment that can be expected to cause your death or that can be expected to last for a continuous period of 12 months. We don't have any short-term disability. There are some states, for example, the state of New Jersey has a temporary disability program where if you're going to be out of work, say, for 6 months, they might pay you short-term benefits. Social Security is not like that. The VA has partial disability where you can get a percentage of disability. Social Security is not like that. It's an on or off switch. So we have two programs, Title II, or Workers' Disability, and SSI, Supplemental Security Income. Title II is, to be eligible for Title II, you must meet recent work. So all of you pay health insurance or car insurance. As long as you pay your car insurance, you're insured and you can get reimbursed for a claim. It's the same way with disability benefits. As long as you've had enough work in a recent enough period, you're going to be eligible to file a claim for disability benefits. So it's generally about 20 out of the last 40 quarters. In layman's terms, it means if you've had work at SGA in the past 5 years, if you stopped working within the past 5 years, generally you would be covered. There's some other rules, but that's a good rule of thumb. Monthly benefits are based on your average lifetime earnings. And when you're on disability benefits, after you've been on the rolls for 2 years, you can qualify for Medicare, which is an important thing. So SSI is the other program, Supplemental Security Income. SSI is funded through general tax revenues, not through your workers' earnings. So SSI can have monthly payments to adults who are 65 and over, or a disabled individual. The requirements, the medical requirements for both Title II disability and SSI are the same. It's the income and resource and the other technical requirements that are different, and Stacey might talk a little bit about that more. And with SSI generally comes Medicaid, another health insurance program that's very valuable for individuals with disabilities. Okay, again, this is an area, sequential evaluation, that Stacey's going to talk a lot about. So I'm going to talk about this some, but I'm going to send most of this conversation to Stacey because I think I like her slides better on it. We have a 5-step process. It is, are you working and earning substantial gainful activity? If not, we move forward. Do you have an impairment that imposes more than minimal limitations on your ability to work? In other words, think standing, lifting, carrying, pushing, pulling. If you do, then we look at, do you have a medical condition that automatically meets one of our automatic disabilities? And then if not, what we look at is your ability to work. We look at your residual functional capacity is the term of art within Social Security. It looks at standing, lifting, carrying, pushing, pulling, concentrating, thinking, getting along with others. We'll look at your RFC and see whether or not you could do some kind of work you did before, or is there other work that exists. All right. So we talk about establishing a medically determinable impairment. Let's talk about that for a little bit. In order for us to find that you have an impairment that we can think about and consider for Social Security, we require some fairly specific things. We require your medical history. We require signs and symptoms and laboratory findings. We cannot establish a medical impairment simply based on somebody's symptoms, and that's in our regulations. So for myotonic dystrophy, what are we going to look at specifically? We're going to look at both physical and mental functioning. We're going to look at your physical limitations, including things like how you walk, how you use your hands, how you're able to do coordinated activities with all your extremities. We're going to look at your ability to remember. We're going to look at depression. We're going to look at personality. We're going to look at any other things that an individual might allege in their application. We're going to look at the whole person. So for myotonic dystrophy in particular, when we're looking at whether or not someone's medical condition is severe enough by itself that we don't consider work, we're going to look at some specific listings. Our listing for muscular dystrophy and other degenerative diseases. We're going to look at one of our listings for speech. We're going to look at one of our listings for organic cognitive issues. And then when we get to the RFC stage, the items are on the screen about what we're going to look at. Now, all this is available online at socialsecurity.gov, and I've given some links at the end of this presentation for people. Okay, let's see. So every 3 to 5 years, our goal is to refresh our medical criteria that we use to make decisions on disability claims. Congress has really asked us to focus on making sure that our policy is current with technology, healthcare, and the world of work. So we have spent a lot of time in the past couple of years updating our medical policy. We have just released our new neurological listings. They are effective the end of September. And some changes that are in there is we've added a listing for children for muscular dystrophy and other degenerative diseases. And we've also added criteria that speak to the combination of limitations that a person with a degenerative disorder might have, so that our adjudicators know to look for that it's very clear to them. Okay, so if we're looking at some specific things in our listing for muscular dystrophy and the myotonic dystrophy, we're going to require that somebody have some specific findings that are up there on the screen, and that's pretty important. It's disorganization of motor function in 2 extremities. So that's what we're going to look for in any medical reports that we get from a physician, a physical therapist, a nurse practitioner, any other medical provider, or any other functional information we're getting from a family member or from the claimant when they're filing their claim. We're also going to require, if we're looking at function, we're going to require limited function in understanding and remembering, interacting with others, concentrating, or adapting. So some of that is, we're looking for evidence of that. So if somebody doesn't have all of those things, that's okay. That's just the things that we're looking for when we're examining the medical evidence. Some basic facts. We look at about 3.3 million claims a year. And of all the people who are allowed benefits, 70% of them are allowed when they file their initial or reconsideration claim. That's important to know, because I think that if you read the news or if you hear mainly from organizations, to go through the entire disability application process from an initial application to your first appeal to an administrative law judge level, we have a lot of claims pending right now. Over 1 million claims are pending, waiting for a judge to hear their claim. Most people who get allowed benefits do not have to wait to go before a judge. So I think that's just important for you to hear that. And the average processing time for claims at the initial level of adjudication is around 100 days. That 85 to 90, I think, is a little old. I think it's about 110. And then for a first level of appeal, it's about 80 days. And right now, again, cases are waiting to have a hearing for over about 500 days before a hearing is ready. So, and the reason I say this is not only to tell you that most allowances happen earlier, but how important it is for anybody who's applying or anybody who's providing evidence to be a good partner in the disability adjudication process, to get the evidence in so that we can make an allowance at the earliest possible time. So things that are helpful for us. It's helpful to have a statement from a doctor. So I'm sure that any patients are generally being treated by a specialist, being treated by any number of medical providers. What we're usually asking physicians or any medical provider for is an opinion about the person's ability to function in work-related terms. And as much as we can get an opinion and the supporting evidence for that is helpful to us. And it's the underlying evidence that supports the opinions that's very important. So we also ask for information about function, because once we have a medical impairment established, it's really all about function. So what we ask is for each individual who's applying for benefits is tell us about how they get through the day. What is it that you can and cannot do? What causes you to have problems? Getting that same kind of information from a third party, such as a family member, a friend, a member of your community that you're involved with, would be helpful as well. We have function reports that once you apply for disability benefits, we're going to ask you to fill out. And again, the tip is talk about how a condition limits daily function. So you can apply for disability benefits online. For Title II benefits, you can apply at socialsecurity.gov. We encourage everyone, this is where I'm speaking in my big hat for Social Security, to establish a My Social Security account. And this is so that you can see your Social Security earnings record once you establish an account. If you're receiving disability benefits, you're going to be able to get benefit verification statements and other information about your disability benefits. You can also file a claim online. So that means that if you're filing a Title II only disability claim, you're not going to have to go into a Social Security office to file. More than likely, you might be able to handle everything online. For SSI, you're still going to have to go in and file. Okay, what we ask when you're filling out your claim is to be as complete as you possibly can. Give us all your doctor's names. Authorize us to get your medical records. It's a different age. When I started the disability program, everything was in paper. I had to sign, if a claimant had to sign a release of information form for each source. Now we have an electronic attestation where you can give your permission electronically and sign the form electronically and attest that it's your signature. We encourage everyone to do that. It does make it quicker for us to get information. Okay, important evidence for anybody to include when you're filling out an application or you're helping someone fill out an application. Talk about your medical records, job history, why you can't do the job you did before, activities of daily living. The more information you give us about where you get treatment, the better it is for you and for the person who's going to adjudicate your claim. So what do we do with the information? Once you file for disability benefits, your claim goes from a Social Security office to a state disability determination services. Each state has an agency that has an agreement with Social Security, and they will develop, in other words, they're going to secure the evidence, they're going to evaluate it, and they're going to make a determination of disability on your claim. In almost every state, that determination is made by a lay disability examiner and a physician or psychologist, sometimes a physician and psychologist. There are 10 states in the nation right now that still have a pilot project in place where only a lay examiner can make a determination. In some cases, that's going away shortly. So our examiners have a lot of training in order to make the determinations, a lot of classroom training, a lot of on-the-job training, but generally we have physicians of all different specialties that work in the DDSs, as well as many that are general practitioners, many in current practice, many that are retired. So it's a good mix of medical professionals. And that is about it. So Kevin?
Terrific. Thank you very much.
You're welcome.
We welcome Stacey, who's going to share her perspective. Go.
Good morning, everybody. Thanks for having me here. Thanks for coming. I'm Stacey Cloyd, as Kevin mentioned, and the place that I work is the National Organization of Social Security Claimants Representatives, or NOSSCR. So what I do at NOSSCR, as Kevin said, is I'm one of their people in Washington. I make sure that the folks at the Social Security Administration and in Congress and in other places know what's going on with Social Security claimants and the people who represent them, and people who get Social Security benefits as well. So like Melissa said, we're going to cover some of the same information, but it's worth hearing twice. And I think we'll put a little bit of a different spin on it. We'll have some different slides. So if it clicked for you one time, great. If it clicks for you on the second time, that's cool too. So NOSSCR it's not NASCAR, although that would be awesome. We're founded in 1979, and we have several thousand members across the country. They're the folks who represent people in Social Security disability cases. Some of them work for nonprofits, some of them work for little firms, some work for big firms. Some are lawyers and some are not, because you actually don't have to be a lawyer to represent people in a Social Security disability case. For our members, we put on conferences, we give them educational material, we help them to be the best representatives that they can be and keep up to date on all the changes with Social Security. And we also offer a referral service for folks who are thinking they might want a representative in their Social Security case. It's a way to find somebody who works near where they live. And what I did before NOSSCR was I was a claimants representative myself. I was a NOSSCR member before I worked there, and I represented people in Social Security claims from the initial part all the way up one time to federal court. Generally, we're fortunate not to have to go all the way there, and we'll talk a little bit about what that process looks like too. Okay, Social Security. Oh, let me go back. So Melissa talked about this. SSI and SSDI are different. They're different in a lot of their rules. They're different in how someone becomes eligible. But one way that they're not different is how they define disability. If you meet the medical criteria for disability under one, you would meet it for the other. You might not have the right income or insured status or immigration status or any number of other things, but definition of disability is the same, so that's good. And it's worth noting that some people get both benefits at the same time. They're called concurrent beneficiaries. And that happens when somebody has paid into the Social Security system, they've paid their premiums, as Melissa said, but they may not have worked a lot, or they may not have worked a lot very recently, and so they don't get a lot of SSDI, Social Security Disability Insurance benefits. SSI, in certain circumstances, can help top somebody up. So it's worth knowing that some people are eligible for both at the same time. So Melissa mentioned, how does Social Security define disability? And it's a 5-step process. So like she said, the first step is, are you doing substantial gainful activity? That's important. Then if you're not doing substantial gainful activity, do you have a severe impairment that's likely to last 12 months or more, or to result in death? If you get past that step, do you meet or equal a listing? And we'll talk a bit more about each of these steps in a minute. If you meet or equal a listing, it stops there. You'll get disability benefits. As long as you qualify for all the non-disability aspects of it, they stop there. But if you don't meet a listing or equal a listing, they look back at whether you can do your past relevant work, and if you can't go back to your old jobs, is there something else that you can do? And if they say, no, this is someone who really can't work at a particularly high level, that's when the benefits would start. So, as Melissa said, SGA, $11.30 a month. It's actually different for people who are blind, so that's worth knowing. It's not just as simple as the amount on someone's paycheck. For example, there are things called unsuccessful work attempts, where someone may have a little bit of income for a couple months that's above the level, but they go back down because of their health. There's also folks who get a subsidy, so their employer, out of kindness or other reasons, may pay them a little bit more than it turns out that their work is actually worth. These can get complicated, but they are worth knowing about. Often it's the amount on your paycheck, but sometimes not. Severe impairment we talked about. It can be the combination of a lot of different impairments as well, and the side effects of your medication can affect impairments as well. Okay, step 3, a listing. What is a listing? A listing is basically a definition of something that's so serious that if you meet it or equal it, you're awarded benefits. And there's a link up there. There are federal regulations, and there's different ones for adults and kids. Let me go back. So Melissa talked a lot about the muscular dystrophy listing, but there's a lot of different listings. And so I went on myotonic.org, and I looked at the list of symptoms that can come up in myotonic dystrophy, and I pulled out, there are listings that could relate to many of them. So musculoskeletal problems has a listing. Cardiovascular for heart abnormalities. Breathing difficulties, there are respiratory listings. Cataracts, there's vision listings. Issues with speech and swallowing, there's the speech ones that Melissa mentioned. There's also for folks who have lost weight, if there's a swallowing issue that has caused a significant amount of weight loss and people have very low body mass indexes. There's also for people who, there's one for inflammatory bowel disease that talks about that. It can be possible to meet or equal some of these listings. Similarly, with cognitive impairments for intellectual disabilities or organic brain dysfunction, depending on when something has started and what the cause of it was. And diabetic symptoms, there used to be sort of a more robust diabetic listing, and now it looks really more at how diabetes affects other body systems. So these are all different listings to look at, and I know myotonic dystrophy can cause a whole bunch of different types of symptoms, so it's useful to think about what somebody's specific symptoms are. Steps 4 and 5, Melissa talked a little bit about that. These are for folks who they got through steps 1 and 2, but they didn't meet or equal a listing. So the person making the decision, whether that's at the state agency or a judge, would look at someone's residual functional capacity, the most that they can do. And they'd figure out, given the most that this person can do, can they go back to their old work? And it's a specific type of old work done within the past 15 years at the SGA level, long enough that you learned how to do it, which of course, depending on the job, some jobs take longer to learn how to do than others. And if they can't go back to that past work, or they didn't have any of that past work, they look at what other work a person could do. They look at using their health, but also their age, education, and work experience. And I will note for children, this is different, because if it was just based on kids' ability to work, we know most kids, terrible employees, they just, everybody would get disability benefits. So obviously you can't just look at, can a kid go to work? They look at domains. Domains are kind of categories of life activities, getting along with others, moving, thinking, that sort of thing. And they look at whether there's one extreme limitation, so an extreme limitation in one domain, or what they call a marked limitation in both domains. And marked has this very technical definition, which is more than moderate, less than extreme. So that's what marked means. And there's some guidance about what that might mean on a percentile basis. And I put that little bell chart there to show marked is, pretty far from average, but then extreme is even further. Okay, that was a lot. So I like to put up a picture of my cat so that people can just take a deep breath. I hope you're not allergic. And if you need to write down some questions, now's a good time. And we'll talk about the application process. Okay, so like Melissa said, it starts out with the initial stage. There's lots of ways to apply. Online is a good one for SSDI, but you have to go in person for SSI. Some people decide to apply for both. That is often a good idea if you don't know what you're going to be receiving. There are ways you can try and figure it out. You can look at your MySSA account, that can be helpful, but oftentimes applying for both can be useful because it just preserves your right to whatever you qualify for. This is a really good time, as Melissa said, to make your record as complete as possible, to gather things from your providers, from the people who know you well, to fill in all the forms that they send you, to make sure that they have the most complete picture of you, because there's usually not a whole lot of chance for you to go and chat with somebody at that point. They're learning about you through paper, so you want to make sure they've got that paper. And as Melissa said, it's state agencies at this level. About 2 out of 3 people who apply at the initial level get denied. Sometimes people say, oh, everyone loses the first time. That's not true. A lot of people do. And it doesn't mean that it's a bad case or that it won't ultimately be decided, but that's sort of the statistic. So if that happens, there's 60 days plus 5 days for mailing to appeal. There can be some good cause extensions if something big is happening in your life. And there's online or paper ways to appeal. In most states, appealing means what's called requesting reconsideration. It goes back to the state agency. But in 10 states that I listed below, they skip the reconsideration stage, and it goes right to the administrative law judge. So whether it's from the initial stage or the reconsideration stage, folks who want to appeal after that go to the administrative law judge. And they get a hearing. Usually you can request it online. So it says their average of 579 days from hearing request to decision. That's as of the end of July. It actually went up to 582 days as of the end of August. This is a long and painful wait, which is why Melissa said, and I agree, if it's possible to win at an earlier stage, that is better for everybody. It's better for Social Security. They don't have to have a judge look at your case. It's really better for the claimant, though, because you don't want to have to wait 582 days more to get a benefit if you could have gotten it sooner. There's some critical case flags for people with terminal illness, 100% VA ratings, wounded warriors, potentially violent or suicidal, or dire need, which comes up if someone's, for example, at risk of homelessness or foreclosure. Some hearings are live, some are on video, but there's always a right to opt out of a video hearing if you don't feel like it's right for you. Sometimes a video hearing can come sooner. There's pros and cons. This is the first chance that a lot of people have to actually talk to the person who's making a decision in their case. So that's a big deal. The hearings are non-adversarial. That means there's a judge, but there's not somebody whose job it is to convince the judge that you shouldn't get benefits. It's just you talking with the judge, and then the judge decides if you get benefits. It doesn't feel like a court like Law and Order or things like that. It's kind of a, it's usually a little bit more of a conversation. There can be medical or vocational experts who testify there. They're the experts on different diseases and on different requirements of different jobs. And then the claimant usually testifies. And I usually tell my clients when I've represented them, you're there, you're going to be sworn in because you're kind of the expert witness on your health and what you can do and what your life history is. And so the judge wants to know those things. It's important to know at a hearing, you usually don't find out how it went that day. It usually takes several weeks or even a couple of months to get a decision in the mail. And last year, of the people who had hearings of those cases, 45% resulted in an award of benefits, 18% got dismissed, and 37% were denied. It doesn't end there, though. So there is an appeals council. There is federal court after that. Those add time, sometimes years. Oftentimes, and in the majority of situations, if somebody loses at a hearing, they have to decide whether they'd like to reapply or appeal. They don't get to do both. And that can be a really difficult and painful decision that's worth thinking about for each individual person. I've had that conversation with clients, and it's never a fun conversation. Neither choice is great. But again, this is why it's important to get as much information in as possible, as soon as possible, so that if it's possible for the judge or somebody earlier to find someone disabled and get to skip this painful part, that's great. At the Appeals Council, 1% of cases were awarded benefits and 15% were sent back down for another hearing. 13%. And in federal court last year, 2% got benefits and 45% were sent back for another review. So this can be a long process. It's not an easy process, but ultimately it's a really important process, and it can help people get some really important financial stability and medical assistance as well in a lot of cases. So should you get a representative? I do work for the National Organization of Social Security Claimants Representatives, so I think you might get a sense of what I would think about that, but I'll say this, it's not, it's a decision that everybody has to make for themselves. It's an important decision. We have a referral service. If if people want to find a lawyer, we are more than happy to match them up with lawyers who work near where they live. Representatives can be helpful. I take one case on a volunteer basis at a time, and I can tell you that in the past month, I have chased down some medical records. I have gone to the medical records offices. I've made a lot of phone calls. I've made sure that things are in the file. Social Security is busy. They do their best. They will request records. If you tell them, I go see Dr. Jones, they will send a letter to Dr. Jones. But I know in the case that I did, Dr. Jones, that's not his real name, didn't send the stuff back. And they sent another request, and he didn't send it back. And so I showed up at Dr. Jones's medical records office, and I called him 10 times. So there's, ideally, you get something out of having a representative, and it may be medical records, it may be writing a brief or a summary of the case, helping ask the right questions at a hearing, and talk with you before and after the decision. It can be a lawyer or a non-lawyer, except in federal court, then it has to be a lawyer. Most representatives charge fees. Generally, the way that works is it's 25% of someone's back benefits, the benefits that have been accruing since between when they applied or when they were found disabled and when they actually start getting paid, up to a cap of $6,000. And the average in a Title II case is about $3,000 in fees. So it's important to understand the specifics for your individual case, but that's generally how this works. And I think what's important if you're thinking about getting a representative is pick somebody who you feel comfortable with, somebody that you feel knows what they're doing. You don't have to be their friend. You're not going to, hang out with them outside of this case. But feeling like they know what they're doing and you feel comfortable with them and you understand how they're going to communicate with you and how you're going to keep in touch over what can be a long process and what they're going to do for you and what you're responsible for doing, that's important. There's lots of folks who handle Social Security cases out there. Pick somebody who you feel good about working with if you're going to work with somebody. Okay. I actually have 2 cats. It's very convenient because I like to have 2 breaks during this presentation. So let's say you get through this whole process and you are awarded benefits. That's awesome. That's really, that can mean a lot to somebody. To have money, to have access to medical care, that's great. But it's not just party, party, party after that. You still have some important things to think about. Reporting things to Social Security so they know if there's any changes in what you're eligible for. Figuring out if you're somebody who has trouble managing your own finances, who might be able to help you, and what Social Security calls that helper is a representative payee. How should you save money or spend? And this is especially important in SSI, which has a resource limit, which is $2,000 for single people, $3,000 for married couples. And what counts as a resource can be a very important issue. And taxation on benefits. These are important things to be thinking about. It is better to think about them ahead of time than when you get a letter from Social Security or a letter from the IRS and you think, oh no, I should have thought about that before. It's good to be proactive on these issues. And the big issue, the one that folks would come into my office when I practice and say, uh-oh, I should have thought about this before, is an overpayment. An overpayment is when Social Security sends you a letter that says, we paid you more than we should have, and we want the money back. And sometimes they can ask for a lot of money back. So it's important to ward these off by making sure that Social Security knows about things that might change your benefits. So work is the big one. There are lots of people with disabilities who work a little. There are some who work a lot. That's great. But Social Security needs to know about that. SSI and SSDI have different policies on how they handle it. Other types of income, in-kind support and maintenance, which is getting free or below market food and shelter, can affect SSI in particular. Leaving the country for a long time. Hospitalization can be an issue, especially in SSI. Incarceration. If they review your benefits and say that you have improved, that can be an issue. And getting married can be an issue as well. Having a child is something often that Social Security benefits from knowing about because it can affect things. So I think when Social Security awards benefits, they give a brochure and it says things that you should know about getting your benefits, and it has a whole list of things to report. When in doubt, tell Social Security. And when in doubt, keep a record of what you told them and when. That's important. If you get an overpayment, you can pay it back. You can appeal it, or you can request waiver of an overpayment. And there are payment plans, there are ways to deal with this. It can be very scary. I've had clients come in with notices saying they owe a lot of money, and that can be really frightening to people. And then Social Security sends these letters, and sorry, Melissa, this is like the bane of my existence. They say, did you forget? And it says, did you forget you owe thousands of dollars, and the person says, well, I didn't forget, it's all that I can think about, it's keeping me up at night. Of course I didn't forget, I just don't have that money. Don't panic. If these things happen, there are ways to deal with them. So I think that it's important to know that don't panic if it happens, but there's things you can do to reduce the chance that it can happen. So Social Security is great. It's also a very busy organization. And the more that you can do to help them and to get accurate information to them, the better. Okay, you did it. That's the end of the presentation. Thanks, everybody.
Thank you. I thought I would just ask a couple of just quick follow-up questions, if you guys don't mind, since we've got a little bit of time. So, Melissa, I wanted to ask you the first question, and the question is there a requirement at the state level of review, or can a applicant request that a medical specialist review their case who may have some knowledge of their particular disease or condition?
So at the state disability level, no, you cannot request that a certain kind of doctor look at the claim. But every state disability agency has licensed physicians, currently licensed physicians. Again, most are in practice, some are not in practice, but they've all had extensive training on the requirements for the general disability program as well as specific disease processes.
Thank you. Stacey, this question's for you. What do you say to folks is the single most important takeaway when someone is applying for benefits? I mean, what would be the one thing that you'd say you absolutely need to remember when you leave here?
Fill out all the forms, and if you don't understand a question on it, ask somebody for help.
Good answer. What's a question for you? Do you, in your experience and time with Social Security and the other work you've done, before that, do you find, so with myotonic dystrophy, as you know, we're classified as a rare disease. Do you find that there are any differences in rejection or folks who were able to get benefits in the initial round between sort of more common diseases and conditions versus rare diseases?
So what happens generally for all disability claims that are filed? There's, as Stacey said, there's 3 levels of application: initial, reconsideration, and administrative law judge. So at the initial level for all claims, the allowance rate is about 34%. For cases with the muscular dystrophies, all of them, the allowance rate has consistently been about 65%. And it's not a large number of people who are applying with where we capture in our data that the impairment is a muscular dystrophy. It's about 2,500 people a year, so about 65% of them get allowed. Those who get denied, about half of them pursue an appeal, and about 20% of those individuals end up getting allowed at the first level of appeal, the reconsideration. If that helps.
Okay, thanks. And then, Stacey, for you, and this is the last question, regarding the overpayments, and Melissa, actually, you can take a crack at this too if you have an answer. Is there any limits on the amount of a repayment that can be requested? Is there a limit on the amount of time that you can look back for that? That was probably the scariest part of the presentation, as far as just knowing that somebody can then come back to you and ask for money back that you may not have. So I wasn't sure if by law there were any sort of guardrails there as to how much you could request. And
So that's actually an interesting topic, and it's kind of a hot topic in Washington now, because SSA tries very hard to collect overpayments, and that's good from a sort of taxpayer basis. If there's money that they paid out that they shouldn't have, they do try hard to get it back. They can go back pretty far when they notice something that's gone awry. So they can ask pretty far back, but there are, like I said, ways to appeal that if you think Social Security's made a mistake, to set up payment plans so it doesn't all have to get paid back at once, or to request waivers. And a waiver is generally saying, yes, I was overpaid, but it's not my fault and I can't afford to pay it back the way that it said. And repayment plans, I've seen them as low as $10 a month. It depends on what the individual's specifics of their financial situation are, the specifics of how they were overpaid. But it's something where I think, like so many things in life, it can be just really terrifying. And when you're scared of something, it's hard to go out there and deal with it. It's easier just to put the notice aside and say, oh, I'll deal with that in a couple months. But it's often better not to wait, and to go in and talk about what your situation is and what you're able to do. And oftentimes Social Security is willing to work with a person on that.
Great, thank you. Well, thank you both very much. Appreciated your presentations, and I want to thank you for your time today. And that concludes today's general session, so thank you all.
Thanks.